Welcome to our public webinar. We are going to give it a minute while everybody's signing on. And we'll just wait one more minute while people are signing on and then begin with some introductions. Okay, I am going to just begin with some housekeeping items to begin with before we begin our presentation while everybody's signing on. Thank you for joining CLS's monthly public webinar. Again, this is always the last Thursday of the month at noon on different topics. We cannot give advice during this presentation. However, you are free to ask any legal information questions. You can do that by writing in the Q&A, and we will do that at the end. Also at the end, I will tell you a little bit about CLS and how you apply for services, how you can receive legal advice if you qualify for our services, but we'll discuss that at the end. But just remember, there's the Q&As there for questions about the law, but we can't give specific advice during our public webinars. I'm now going to hand it over to our guest speaker today. We are so excited to have Lori Bird here, who is an expert in education law and presenting this public webinar for us today. Lori, take it away.
All right, I am kind of going to jump right in here. As Pam said, I have been doing education law for 20 plus years, probably more than I'm going to admit. And hopefully I'm going to answer some of your questions so that you have information you might need. Hopefully you never will actually need this information, but information you might need if your child, friend's child, relative's child runs into a bit of trouble at school. Next slide, please. I do have to tell you, as Pam indicated, that the information I'm providing is for informational purposes. And if you run into any of these situations, please reach out to your own legal advisor for specific situations you might encounter. The Arizona Bar makes me say that because although I am an attorney, I am not your attorney in this forum. Next slide, please. So we're going to talk about suspensions, expulsions, and how they're different and what your rights are as a parent and what your students' rights are. We're going to start with me saying that all discipline is not the same. The school does have the ability to discipline your student for infractions of school rules and policies. Those school rules and policies are usually found in the packet you receive at the beginning of every school year, where they list what their rules, policies, rights, and obligations are. So all discipline is not the same. There's no need to panic if your child makes a mistake. There are processes in place by which you can work that through. So when we look at suspension or expulsion, we have discipline that's less than 10 days. We have long-term suspension. We have expulsion. And then we have some twists on those, depending on the grade level of the student and whether or not your student has a disability. Next slide, please. The first thing we're going to talk about is suspensions 10 days or less. A school district may suspend a student in grades 5 through 12 for 10 days or less without conducting any kind of formal hearing. Now, this doesn't mean that there aren't some protections for your student. However, schools have a lot of leeway in enforcing their, what I'm going to call minor violations of school policy. These are your 1, 2, 3, up to 10 days where your student is asked to leave school and then returns on a set date that is less than 10 days hence. Next slide, please. So this is less serious infractions of the school's code of conduct. Sometimes they call that the student handbook. They're more minor in nature. You may get a detention or a privilege removal instead of a suspension. Or things that you've gotten a suspension or a privilege removal for in the past, and your student keeps doing those things, may result in what we call these short-term suspensions. These are usually one and done. And I'm going to be really candid when I say I'm going to give you things that you should do if this happens. But by and large, your student is going to serve this suspension and then they're going to return to school. And there's not a lot of good ways to get that type of suspension overturned or taken off their record. The good news is there is really no long-term consequence to your student if they receive a short-term suspension. And that includes in college admissions, particularly for anything that occurs before 11th or 12th grade. So short-term suspensions are for misconduct, bad judgment, and mistakes. However, they don't derail your student's educational career either as they progress grade to grade or as they're applying to college, trade school, the military, whatever it is they're going to want to do post-secondarily. Next slide, please. So if you are told, and the school will notify you, that your student has received a short-term suspension, they'll tell you for how many days your student needs to be out, and they'll tell you why, what happened, what rule did they break. You can request to speak with the principal, vice principal, or dean of students, whichever administrator in your school handles the discipline. You can ask about the circumstances of the discipline and how your child was involved. And the important question you want to ask is, did your child get an opportunity to tell his or her side of the story? This is the right that your child has. They get to say, I didn't do it. Whether or not they get believed or whether or not the school agrees is a different question, but your student should always get the opportunity to be heard. One piece of information you won't get when you start asking about circumstances is the names of other students and any discipline or consequences that other students were given who might have been involved in whatever the violation was. You can ask to see the statements. Sometimes schools have incident reports or witness statements, but you don't necessarily get to know the names of those other students because that's protected by a law called FERPA, the Federal Educational, I forget the acronym. It's FERPA. It just went out of my head. I use it every day and I forgot it. Sorry about that. I will get that to you. But you can ask questions specific to your student. You want to look at the student handbook to understand what the school is basing the discipline on. So ask them, what rule did they violate? Look at it and see if suspension for a certain number of days is listed as a consequence for the violation of that rule. You, of course, want to talk to your child. Ask them what happened. Ask questions about what happened. Here's an important one. Ask if your child is allowed to complete assignments or log into whatever portal the school's using, and if their grades or credits will be impacted. You don't want a short-term suspension to cause your student to fail assignments. And in most cases of a short-term suspension, they will be able to make up major tests and assignments. But sometimes you do have to specifically ask, and then it's your responsibility that your student turn in those assignments when it's requested. They may not be able to turn in assignments that are more routine, that count for a minor part of their grade, but you really want to focus on those assignments that are going to impact their grade for that quarter or that semester. And you want to know the exact start date and the exact end date of the suspension. And sometimes a meeting is required when your child returns, and there may be certain criteria placed on your child short term as they transition back into the school. Your student may be asked not to contact others or talk about with other students the reason for their suspension, or to target other students, post about it on social media, create any kind of disruption in the school environment as a result of their suspension. So those are short-term suspensions. They are important as children learn and grow as a consequence for mistakes or violations of school policy, but they shouldn't derail your child's academic career. Next slide, please. If there is a violation of a school policy rule that is more major in nature, repeated fighting, possessing vapes, injuring another student, perhaps throwing a chair and causing disruption in the classroom that can't be managed by the teacher, threatening teachers or other students, things that might fall under harassment under Title IX, and we'll talk about briefly about some of the provisions of Title IX. That's sexual harassment or behavior based on sex. This is a much more concerning disciplinary practice. And because of that, there is a formal process that your student has that does protect them. You will get a formal notice and opportunity to be heard in a hearing, whereas for a short-term suspension, you don't get any hearing. You might get a meeting with the principal or the assistant principal. Your student might meet with whomever handles that discipline, but there's no requirement of a formal hearing. For a long-term suspension, there might also be alternatives to suspension that can shorten the duration of that suspension. And a long-term suspension is technically anything more than 10 days, but it's more likely to be at least a semester or until the end of the school year. It's not an expulsion because it's not indefinite, and your student can come back after a set period of time, but it's typically at a minimum a quarter and more usual it is for the remainder of the school year. However, you may be able to ask for alternatives or to ask that that be shortened if certain conditions are met. So, yep, next slide. You read my mind, Pam. What can you do? You're going to start with a lot of the things that you did initially. You're going to talk with the administrator, with your students, so that you know what your student is being accused of doing. You're going to ask to see any video or other evidence. You are allowed to see video. That is not a FERPA violation, Federal Education Rights Privacy Act. What you can't do is get a copy of that video unless it's redacted with all the students blurred out. However, you can ask, may I see the video of what happened in the cafeteria? May I see a video of what happened in the hall? If your student's accused of vaping in the bathroom, this is very common. And some districts are going long-term suspension for that, or others require a repeat offense. But you can say, can I see the video that was outside of the restroom of my student going into the restroom at the time that you say they were found vaping or using drugs in the restroom. If you see statements, witness statements, again, other students' information may be removed. Please do not have your student contact any other students, nor should you necessarily contact other parents in a way that's confrontational. Talk to your student. What do they say happened? You will get what's called a suspension packet. If your student is being suspended long-term, more than 10 days, they have to have a formal hearing. That formal hearing might look different in different school districts. Some school districts have a hearing officer that they hire from the outside. Some districts have an internal hearing officer who's not familiar with what happened. And some school districts have their governing board hold these hearings. It is more common to have a hearing officer, either internal or a hired third-party hearing officer. You are going to get sent a packet of information. It's going to have, and should have, what it is your student is accused of doing. It should have a copy of the policy or code of conduct that they violated and the discipline that can be imposed. It should have the evidence that they are going to use in the hearing. And obviously, it will have the date and the time of the hearing. You absolutely want to show up at the hearing. There is a misconception out there that if you just say, I am removing my student from the school, I am unenrolling them, that long-term suspension won't be placed on their discipline record. That is not true. Even if you unenroll your student, that doesn't make the disciplinary consequence go away. So it is to your benefit to show up at the hearing. Ask if there are any alternatives to long-term suspension. Sometimes, particularly in drug offenses, the school first-time drug offenses, schools have a policy or procedure whereby if your student gets counseling, you pay for some drug testing, they agree to some other contractual behavioral expectations, that the student will not receive a long-term suspension and they'll continue to go to school. Because remember, a long-term suspension means that they are not allowed to attend school. And it also usually means they can't engage in any extracurricular activities or attend as a viewer any extracurricular activities. They're not allowed on campus. So you do want to ask if there's alternatives. Sometimes the alternative is your student won't be allowed on campus. They won't be allowed to attend extracurricular activities, but they may be allowed to enroll in the district's online school. So at least they can continue with their academics. Usually they do not allow a student on a long-term suspension to continue participating through packets or online with their regular class or cohort. If there are no alternatives to the long-term suspension, you want to attend the hearing. This is your opportunity to present your student's side of the story and to show that they really shouldn't be long-term suspended. You can have your student take responsibility and acknowledge accountability. You can offer evidence as to remedial steps you've taken as a parent. Perhaps your student's in counseling. Perhaps you've done other things as a parent. The hearing officer will take all of that into consideration before they make a determination that the student should be suspended long-term. And again, that long-term suspension is for a date certain at the end. You can, by your school's policy, ask that that be reviewed if certain criteria have been met at an earlier date. But for a long-term suspension, I'll be honest with you, that's not usually granted. And unless the governing board conducted the initial hearing, you have a right to appeal the hearing officer's decision to the governing board. And they should do that in what's called executive session so that everything that's being said isn't aired to the public. If you feel like your child has been discriminated against because of race, gender, disability, you do have other appeal options, including the Office for Civil Rights. What I will tell you about the Office for Civil Rights is that although the complaint is easy to file, the process takes a very, very long time. And it is likely that your student will have served the long-term suspension before that process is complete. You do want to look at your child's discipline record to make sure that the discipline was coded correctly and that the details of the discipline are fair. It says what your child did, but they're not inflammatory. So after the discipline is imposed, you want to get a copy of your child's discipline record to make sure that the discipline was described accurately. And if you feel it wasn't, you can put a statement in there that says this record is erroneous. Here's what I think happened. It doesn't change the discipline, but from a long-term records perspective, it at least has your perception and your statement in there. The other thing about a long-term suspension is that it does allow your student under Arizona law to open enroll. Next slide, please, Pam, sorry. Can you open enroll in another district? Yes, under our open enrollment rules, the answer to that question is yes. However, some school districts will honor the discipline from another school district. Others, many, including charter schools, do not. Now, if it's a middle of the school year suspension, you may find that your charter schools are full. And so they are not enrolling any student because they're at their capacity. Same with open enrollment. But you can, so that your child's education continues, try to enroll them in another school district or in a charter school. Your priority, if the discipline is imposed, is to make sure that your student doesn't fall behind academically, and obviously to address the behavior like any parent would. You do have options beyond other school districts or charter schools. There are many online options, and many school districts, even the school district that long-term suspended your student, will actually allow you to enroll if they have an online program. There are other charter onlines. There are private onlines. You can homeschool your student. I do not believe that there is any prohibition on getting ESA, Arizona Empowerment Scholarship Account dollars if your student's been suspended, long-term suspended or expelled, for you to homeschool your student. But you do want to look at all your options so that when your student returns to the public school, they're not behind. You can also try private schools, but again, most of those won't enroll your student mid-year, although some will. So you want to look at all your options to make sure that your child's academics are continued to be delivered while they're out of the public school. Next slide, please. Man, I'm 25 minutes. Expulsion. Most serious offenses. Guns, automatic expulsion. By law, nothing you can do about it. Serious bodily injury. Your student will be expelled. Threats to an educational institution. They threaten to shoot up a school, even on social media. They will be facing expulsion proceedings. That is permanent removal and enrollment from the school setting. Although you will have an opportunity to reapply, most school districts do not even allow you to reapply until a full year has passed. Also, selling drugs will get your student expelled, whereas the use of drugs may not. Some of these offenses automatically get you a 45-day alternative replacement, but unless you have a child with a disability, you are most likely going to be facing an expulsion, which does have the same protections we talked about with the hearing. And you should do all of the things that you've done for your long-term suspension. Next slide, please. This is essentially the same list that we went over. However, if your child is facing an expulsion, it is definitely worth the money for you to contact an attorney if you have the resources, or to reach out to an organization like CLS to see if they can help you, because this does have a big impact on your child's ability to continue their education. It also has a big impact on their college and post-secondary prospects if it happens in second half of 10th grade, 11th, or 12th grade. Not so much if it's junior high or elementary school. You can also ask for alternatives. Can I agree to withdraw my child? You will code it as a long-term suspension, and there'll be other agreements. It's called the stipulated agreement. You should always ask the school, can we enter into a stipulated agreement rather than have my student face expulsion? Because once an expulsion is moving forward, it really limits your students' options to move forward with their education beyond homeschooling. The district governing board makes the final decision. The hearing officer only recommends, so there'll also be a governing board decision on expulsion. Next slide, please. Here are some general tips. Please be aware social media activity can result in any of these disciplines. Document everything. That doesn't mean you have to conduct everything by email, but if a verbal conversation occurs, make sure you confirm it through some kind of written documentation. Please review the student handbook or code of conduct with your student at the beginning of the school year so that they understand the consequences for certain behaviors. The rest we've gone over, and because of time, I'm going to move on. But we can certainly answer questions at the end. Next slide, please. If your student has a disability, and this is a whole nother training, that's either a 504 plan, an IEP, or there being an individual education plan. So they have protections because they have disabilities. There is a whole nother set of protections under the IDEA or Section 504 of the rehabilitation plan. If your student is in grades K through 4, it is much more difficult to impose a suspension on that student, and long-term suspensions and expulsions are they're not impossible, but almost unheard of, except in the case of a gun, which is mandatory for all students. That's mandatory expulsion. And then if you run into a Title IX, your child is accused of violating Title IX, which is conduct such as sexual assault or sexual harassment. That student cannot be disciplined until all of the requirements of Title IX are followed, which includes an impartial investigation. Next slide, please. If your student has a disability, please reach out and make sure that they get a manifestation determination. If it is a suspension that is more than 10 days, or if it's a series of short-term suspensions that are going to equal more than 10 days. The most important thing to know if your student has a disability is although your student can be disciplined, the district or charter school still has a legal responsibility to provide a free and appropriate public education, even if a long-term suspension or an expulsion is the disciplinary consequence. Please consult an attorney or an advocate if you run into a situation where you feel as if the IDEA, or Individuals with Disabilities in Education Act, or Section 504 of the Rehabilitation Act is not followed. Next slide, please. Students in grade K through 4, as I said, have some additional disciplinary protections. They may only be suspended for 2 days at a time, and the school has to have a lot of proactive measures put in place if they notice that a student is incurring disciplinary infractions. Arizona, this is the only statute I'm going to give you. It's Arizona Revised Statutes 15-843, and there's a long list of protections for students in K4 because it's particularly damaging to students in the younger grades to miss out on that instruction. And so Arizona has made it very difficult to remove those students from schools without significant process being in place first. Next slide, please. Weapons, drugs, immediate safety risk, severe persistent behavior problems are some reason that K through 12 students may be facing significant discipline. Next slide, please. Here are the things the school needs to do before they even impose a suspension of longer than 2 days on your student. And the provisions for readmission are much shorter. And if the behavior continues, the school may have to initiate an evaluation to determine if the student has a disability. I suggest you cooperate with the evaluation process. Next slide, please. Title IX, as we discussed, is for specific types of conduct. Your student cannot be disciplined for sexual assault or sexual harassment before all of the investigative processes are completed. And only then, when it's been determined after a full investigation, may the school move forward with any kind of adverse discipline. Now, they might separate the students, or they might put in place measures for your student's own protection, but they cannot be given any type of discipline before the Title IX process is complete if they're accused of sexual assault or sexual harassment. And again, if you want to know more about that, I think there are other trainings available specifically on this issue in the K through 12 setting. Next slide, please. We are at the question and answer portion, and I'm only 4 minutes over. Pam, do we have any questions?
So far, we don't have questions. So what I'm going to do to give everybody a moment to add questions if they want is to just go quickly through how people apply for CLS if you're interested. We are a nonprofit law firm that serves people in civil areas of practice. We try to advocate, litigate, and educate on behalf of Arizona's most underserved communities. We practice in civil practice, and education is one of those areas that we practice. We're located in Maricopa, Yavapai, Mojave, La Paz, Yuma, and Farm Worker. But if you are joining us, and farm workers throughout the entire state, if you are joining us from other parts of the state, we have sister organizations like SALA and DNA who handle other areas of the state, but also in our same practice areas. How to reach us. So again, today if you do have questions, you can put legal information questions in the Q&A. But we can't provide advice. But if you need advice and you believe that you'll qualify for our services, or you need someone to assist, an attorney to assist you with more than advice, you can call us. at 602-258-3434, 9 to 2, or online. You can see on our website also shows how you can apply online. If you're in Maricopa County, we are located in person at Native Health, Peoria, and Mesa Can. Every week, you can come in person and apply for our services at those locations. I am now, and you can also follow us on social media. And let me see if we have questions now in our Q&A.
I do see one, Pam.
Yes. Can you, I'll say the question out loud just so that everybody knows the question. What is a manifestation determination review that the school must conduct with students who are disabled and are potentially facing long-term suspension? What does that entail?
So before a long-term suspension or expulsion can be imposed on a student with a disability, it's similar to an IEP meeting. But what they're looking at, your IEP team, which includes you, your individual education program team, or people who are involved with your student's 504 accommodation plan, meet together to determine whether the behavior that led to the discipline or the proposed discipline was what's called a manifestation, or essentially was caused by the student's specific disability. And because the public policy is that we don't punish people or discipline students for behaviors that are part of their disability or as the result of their disability, this team of people, of which the parent is a member, meets to discuss, was the behavior the result of the student's disability? If it was, then no discipline can be imposed on that student. They can't be long-term suspended or expelled. They can receive short-term disciplinary consequences because a manifestation determination review does not kick in until the student is either facing 10 or more days of suspension or an aggregate of 10 or more days in a single school year. So it is a protection for students with disabilities so that they are not given long-term consequences, disciplinary consequences for behavior that is part of their disability. Now, the other thing that a manifestation determination does is not only does it determine whether or not the student should be disciplined, but whether or not that student needs additional supports. Do any additional evaluations need to be done? Do they need a behavior plan? Does their placement need to be changed? So sometimes schools will do a manifestation determination just to discuss, hey, here's the behavior. Hey, we know that the student did that because of their particular disability. And we're going to make that determination. But now we're going to have an IEP meeting, or we're going to look at their 504 plan to see if there's additional supports we need to put in place to help that student learn more pro-social skills. Hopefully that answered in a very short way the question. Again, there are, if you're facing that, you can reach out either to Community Legal Services. There's also Disability Rights Arizona is an organization that can help parents of students with disabilities. There's also Encircle Families that also has resources for parents of students with disabilities in many areas, but also specifically for disciplinary issues.
If we have any questions right now, I just want to thank you so much, Lori. That was really informative. It will be on our YouTube channel in a couple days. This was being recorded so that you can review it again and be able to see that. So that will be on the CLS YouTube channel. Thank you so much, Lori. This was really, really helpful. And I'm so grateful that you gave your time and expertise to us today.
Anytime, Pam. Thank you all for being here.